suppose the kids are there, they would like to buy the company. Now that's going to be a touchy issue since it's within the family. In talking about the emotional factor, what are some of the pitfalls that they have to consider working with your own family?
Well, that's a whole different dynamic. It depends on the relationships that exist in the family. Who's going to be the owners? How much are they going to own? Are the parents going to sell it outright? Are they going to sell it out over time? Are there going to be benchmarks and achievement of sales levels that the children have to reach to buy more shares in the company and to be able to buy the whole thing? And the children don't necessarily take after their parents. They don't necessarily have the same abilities, the same drive, the same constitution makeup that the parents had. They're not as hungry a lot of times.
Now, what about if you have stockholders in the company and you have other investors in the company? How would that change the dynamics?
It depends. It depends on the written agreements between the parties. Hopefully, if it's a partnership, there's a partnership agreement, or if there is a corporation, there's a shareholder agreement that will spell out the rights and obligations of the parties. In many instances, that doesn't exist. Many family-owned businesses do not particularly pay attention to what I would call the legal niceties and keep things clean from a legal standpoint. And the function of an attorney who comes in and represents them, his first duty is to do what I would call internal due diligence. To see what he's dealing with. The lawyer would have to find out how the company operates, what the relationship among the owners are, whether or not all the owners want to sell, whether there's any dissension, are there buyout issues that are involved. And it helps if there's a written agreement, because that could be the guidelines for a buyout with existing partners. So it's a totally different dynamic.
Now, if you have a partner, let's say a stockholder, all the stockholders agree except for one. And because of a personal issue, because of it could be ego, it could be whatever it may be. How do you get around that? I mean, when most people agree, and they do hold the majority stake in the company, and yet you have one sort of holdout. How do you deal with that?
Depends if there's an agreement or not.
Okay.
If there is an agreement, it probably will say something like the company can be sold or merged if a certain percentage, usually more than a majority, 2/3 or 75% of the owners, vote to proceed with the sale. Then they have to go along with it in many instances. If they don't, they're exposing themselves to legal ramifications. But the simplest way to explain it would be, if you don't have an agreement, you have a lot of potential problems. It's very, very important for the owners of the business, if they bring in outsiders, particularly investors who invested money or who sold them equipment to run their business and did that in consideration of their partnership or stock interest, that their rights and liabilities and obligations are spelled out. If they're not spelled out, it could be a very serious problem. It could hold up or kill the transaction.
Now, do you recommend, even with a family situation, that each person involved in the transaction get their own attorney?
Yes. There are inherent conflicts of interest between the counsel that represents the company and the counsel that may represent the shareholders. Of course, you can get written waivers of the conflict, and then the counsel who would represent all of the parties will have a particularly interesting role to play, because ethically, lawyers are required to represent their clients in the utmost and most effective way possible. They always have to be advocates for their clients' interests, regardless of what it is.